Good morning. My name is Jennifer Conklin, and I will be doing today's presentation on reasonable modifications. First, I'll start with some background about elder law and advocacy and our programs. ELA is a nonprofit organization. We have offices in Claremont and El Centro. Seniors need to be at least 60 years old to be eligible for our services, and we provide free and low-cost civil legal services, Medi-Cal and Medicare-related counseling and advocacy, referrals to community senior service providers, and community education. This presentation is put on as part of our Elder Tenant Assistance Project. As part of our ETAP program, we provide legal services to at-risk seniors to assist clients with landlord-tenant issues prior to litigation. I specifically provide legal assistance to clients with significant habitability issues. And today we will be discussing the Fair Employment and Housing Act regulations related to reasonable modifications. Please note, providing this legal information does not form an attorney-client relationship, and the information today does not constitute legal advice. We always suggest that you consult an attorney about your specific situation. So we'll start with an overview of the law. Sections 12900 through 12999 of the Fair Employment and Housing Act protect individuals from housing and employment discrimination and from the harassment on the basis of protected characteristics, and disability is one of those characteristics. The FEHA regulations related specifically to reasonable accommodations and reasonable modifications are found at sections 12176 through 12181. And here again is a brief overview of the reasonable modification regulations. Section 12176 covers obligations to provide reasonable modifications. Section 12177 covers the required interactive process. Section 12178 covers determining the necessity for the modifications. Section 12179 covers the limited reasons for denying a modification. And then section 12180 and 12181 contain additional requirements and examples. Most of these sections address both reasonable accommodations and reasonable modifications. However, section 12181 is only related to reasonable modifications. So, some definitions. Disabilities are broadly defined and typically require a limitation on a major life activity. Housing accommodations are also broadly defined, and they include all types of dwellings, such as rentals, common interest developments or condominiums, and shelters, and all types of housing opportunities. Disabilities under FEHA. Disability is one of the many protected bases under the Fair Employment and Housing Act. FEHA protects individuals with disabilities from discrimination, as does the Federal Fair Housing Act, the American with Disabilities Act, and Section 504 of the Federal Rehabilitation Act. One type of discrimination specifically prohibited by FEHA and these other laws is the failure to make reasonable accommodations or reasonable modifications when such accommodations may be necessary to afford a person with a disability an equal opportunity to use and enjoy in a housing accommodation. Accommodations and modifications are required in all types of housing and housing programs under FEHA. Reasonable accommodation versus reasonable modification. A reasonable accommodation is an exception, change, or adjustment in rules, policies, practices, or services when the accommodation is necessary to afford an individual with a disability an equal opportunity to use and enjoy a dwelling unit and public and common use areas, or an equal opportunity to obtain, use, or enjoy a dwelling or housing opportunity. An example of an accommodation could be a tenant requesting to pay rent by the 7th of the month after they receive their Social Security check rather than the 1st of the month. A reasonable modification, on the other hand, is a change, alteration, or addition to the physical premises of an existing housing accommodation when such modification may be necessary to afford the individual with a disability equal opportunity to use and enjoy a dwelling unit and public and common use areas, or an equal opportunity to obtain, use, or enjoy a dwelling or housing opportunity. So FEHA and the Fair Housing Act use the term reasonable modifications to refer to physical changes to the property. However, the Americans with Disabilities Act and Section 504 of the Federal Rehabilitation Act use the term reasonable accommodations to apply to both policy changes and physical changes to housing. For purposes of this presentation, I will use the term reasonable modifications to refer to the physical changes to property. Examples of reasonable modifications include installing a grab bar in a bathroom, widening doorways to make rooms more accessible for persons in wheelchairs, lowering kitchen cabinets to a height suitable for persons in wheelchairs, adding a ramp to make a primary entrance accessible for persons in wheelchairs, altering a walkway to provide access to a public or common use area, installing blinking doorbells or emergency alarms to provide alerts to someone who is deaf, or braille signage for someone who is blind. Failure to provide reasonable modification. It is a discriminatory housing practice for any person to refuse to allow an individual with a disability the opportunity to make reasonable modifications to the premises of an existing housing accommodation that is occupied by or will be occupied by an individual with a disability. the reasonable modification standard. The person making the request must have a disability, and the requested modification must be related to the disability and necessary for the person with a disability to provide them with an equal opportunity to use and enjoy their dwelling and/or common areas of the dwelling. The reasonable modification request. The request must be made by the individual with the disability or someone else authorized to act on their behalf. The request can be made at any time, including in the application for housing and through an eviction proceeding. The duty to provide a reasonable modification is ongoing, and with limited exceptions, all information concerning an individual's disability, accommodation request, and medical verification must be kept confidential unless disclosure is required to make or assess the decision to grant or deny the request for modification, if disclosure is required to administer or implement the requested modification, if disclosure is authorized by the individual with the disability and in writing, or if the disclosure is required by law. The procedure for requesting a reasonable modification. A landlord or property management can create forms or procedures for requesting a reasonable modification, but they cannot require them. The landlord or property management must engage in what's called the interactive process, regardless of how the reasonable modification request is made. Forms and procedures put in place by the landlord or property management cannot seek information that's not necessary for evaluation of the request. And forms and procedures put in place themselves are subject to requests for reasonable accommodation. So for example, a tenant may request an alternative method of communication during the reasonable modification process. This request is also a reasonable accommodation that must be responded to in the same manner as any other request. In many circumstances, such requests or persons considering the request may also be covered by the American with Disabilities Act and its accompanying regulations that require the provision of auxiliary aids and services and alternative methods of communication. Reasonable modifications and unlawful detainer proceedings. An individual with a disability may raise the failure to provide a reasonable modification as an affirmative defense to an unlawful detainer action. A request for reasonable modification can be made at any time during the eviction process, including at or after trial, and in certain circumstances after eviction. The interactive process. What is the interactive process? If a request is not immediately granted, the recipient must engage in dialogue with the requester to reach a solution. The process must be timely and conducted in good faith. if there is insufficient information about the disability or nexus, the person considering the request cannot deny the request without seeking clarification or additional information. When the requested modification is not granted immediately, the person considering the request must suggest an equally effective alternative modification. Equally effective means that it will allow the person with a disability to use and enjoy a dwelling or housing opportunity as well as the requested modification would have. The person with a disability has no obligation to accept the alternative if it doesn't meet the needs of the individual with the disability. The person with the disability has the most accurate knowledge about their functional limitations posed by their disability, and so that individual's preferences should be given weight. Time to respond to a request for reasonable modification. Requests are considered on a case-by-case basis. The time necessary to respond to a request depends on the nature of the modification, whether additional supporting information is necessary, or whether the modification is urgent. Failure to act promptly or no response for a person considering their request could be considered a denial of the modification. If after denial of an initial request, the requester makes a later request, which is similar to the initial request, it must be considered independently of the initial request. So a second request, therefore, cannot be denied just because the very similar initial request was also denied. Establishing a reasonable modification is necessary. The person considering the request, landlord or property management, may not seek information beyond what is necessary to evaluate the request. They can't request a specific diagnosis or medical records, and the person may not ask for additional information if the requester provided reliable information about the disability and why the requested modification is necessary, or the disability or necessity is apparent or known. So apparent means that either the disability or need for the accommodation is obvious, and some examples of this would include use of a wheelchair, being blind, being deaf, or being hard of hearing. Information establishing a disability can usually be provided directly by the individual requester through a process called self-certification. Self-certification methods include documentation of receipt of disability benefits or a credible statement by the individual with a disability. What's considered a credible statement by the individual is one that a reasonable person would believe is true based on all the information available. If not through self-certification, information may also be provided by a reliable third party who knows about the disability or the disability-related need for the modification. The third party does not need to be a medical professional. It can be from a non-medical service agency. for example, in-home supportive services or supported living services providers, or it can even be a relative caring for the individual or another caregiver. Denial of a reasonable modification. So when can a requested modification be denied? It can be denied if the requester does not have a disability or cannot demonstrate a disability-related need for the modification. The requester refuses to pay for the modification unless the housing provider is required to pay by law, which I will get to later. It can be denied if the requester refuses to provide a description of the project or plans for the project to be done in a competent manner or to obtain required permits. And it could be denied if the requester refuses to agree to restore any changes to the interior of a rental unit at the time they move out. A request for reasonable modification can also be denied if it constitutes an undue financial and administrative burden or fundamental alteration. Generally, financial and administrative burden is not a defense because the requester is paying for the modifications. Similarly, fundamental alteration would rarely be a defense since by definition, reasonable modification relates to the physical modification of housing. However, if the housing provider is paying for the modification because it is subsidized housing or for other reasons set out in the regulations, these defenses could be made on a case-by-case basis, and they must consider the cost and financial resources if the housing provider is required to pay, the benefits and availability of alternatives to the modification. A reasonable modification cannot be denied because it would be perceived as unfair to others, or it might become burdensome if extended to others. So when is the housing provider required to pay for the modification? A housing provider must pay if the housing is government subsidized, if the housing provider is a government entity, the housing provider is a recipient of federal or state funding for affordable housing, or the housing provider is part of a government entity's program or activities to provide housing. If the modifications are needed because of a failure to maintain the housing, and in particular, they're needed because of a failure to maintain an accessible feature, an example would be an elevator. And if the accessible feature was required by building and accessibility codes at the time of construction, but the building or housing provider failed to comply with those codes. Restoration. Housing providers can require tenants to agree as a condition of granting the modification that when they move out, they will restore any modifications to the interior of a rental unit to the original condition. This only applies to interiors of rental premises, not exterior, or common areas. Housing providers can choose to restore or maintain those modifications at the provider's expense. And restoration requirements do not apply to common interest developments, subsidized housing, modifications done to correct maintenance issues or original code violations, or modifications made as part of a purchase of a for sale housing accommodation. Restoration continued. A housing provider can refuse to grant the request for modification if the requester refuses to commit to restore the interior modifications if restoration was part of the final modification plan, or if restoration is reasonable. And it's a case-by-case analysis that considers if the modifications affect the housing provider or subsequent tenant's use and enjoyment of the premises, or if the next tenant will need the modification. Escrow funds for restoration. A housing provider can require that tenant put funds in escrow to restore the premises. A housing provider cannot automatically require funds be put in escrow if restoration is required, and it can't require full amount to be paid prior to permitting for modifications. Determining whether escrow is necessary or determining the amounts and terms of an escrow is a case-by-case determination that considers the nature and extent of the proposed modifications, the expected duration of the lease, the credit and tenant history of the tenant or applicant, the amount of any existing security deposit, the impact of non-restoration on the future usability of the premises, and other information bearing on the risk to the housing provider. Design and competency of the modification. A housing provider can condition the modification on reasonable assurances the work will be done in a competent manner and that any required building permits be obtained. They can also condition the modification on a reasonable description of the modification. Reasonableness is determined on a case-by-case basis and will vary based on the location and nature of the proposed modifications. For example, the housing provider cannot require the work to be done by a specific builder or contractor, or that they even have a license, except under certain circumstances. Other limitations on modifications. Maintenance of a modification may be the responsibility of either the tenant or the housing provider. Modification in a space under the responsibility of the tenant should be maintained by the tenant. Modification to an area normally maintained by the housing provider, such as a ramp to the building, is the responsibility of the housing provider. Providers cannot impose other conditions for the modification, such as liability waivers or insurance requirements. Providers cannot insist on an alternative modification or design unless it is done to a common area or an interior of a unit where it is unreasonable to be restored. The alternative must not raise costs and must still meet the needs of the requester. And modification requirements apply to all housing accommodations, regardless of the age of buildings. Remedies for denial. If a tenant requests a reasonable modification and they have been denied and believe they have wrongfully been denied, you can file an administrative complaint with the Department of Housing and Urban Development or the California Department of Fair Employment and Housing, and you'll want to file within 1 year of the incident. Alternatively, you could file a lawsuit in federal district court within 2 years of the incident. Lastly, here are some additional tenant resources. Housing is Key provides resources for renters, landlords, and homeowners. Disability Rights California is another nonprofit which provides advocacy services to clients with disabilities. The Legal Aid Fair Housing Center also provide advocacy services related to housing discrimination. And lastly, we have the Department of Fair Employment and Housing and the San Diego Lawyer Referral Service that you can contact for referrals to lawyers for whatever your claim is. This concludes our presentation on tenant rights, reasonable requests for modification. Please feel free to contact us with any further questions you may have.